Good afternoon and welcome to Miller Thomson's Health Industry Group Director Series. My name is Kathryn Frelick and I am delighted to be speaking with you today about protecting privacy obligations of directors. In terms of our agenda today, we're going to start with an overview of key concepts to make sure that we're all on the same page and understand the same language. We'll talk about obligations under privacy legislation, in this case, focusing on the Personal Health Information Protection Act and Freedom of Information Protection of Personal Information Act. We'll speak a little bit about board obligations and information governance. The next stage will be identifying new and evolving privacy and cyber risks. As you'll all be aware, there are changes all of the time relating to privacy and cyber. We see lots of information in the media. There are new and evolving cybersecurity risks that organizations are facing, and they really are evolving areas of practice. Finally, we will talk about some strategies and best practices to manage and reduce risk and liability. So to start off, traditionally there was no right to privacy in Canada, in that you couldn't sue someone for breach of privacy. If there were concerns, you really had to sue in connection with another cause of action. So, for example, if there was a breach of contract matter where there was a confidentiality aspect, or you could sue someone for negligence relating to confidential information, but there was no ability to bring an action for breach of privacy. And that has changed fairly recently in January of 2012 with the development of a number of privacy torts that are still developing in Canada. In the health sector, traditionally the focus has been on confidentiality and professional obligations. The legislation that exists relating to health records really dealt with access to and disclosure of health records themselves, set out in the Public Hospitals Act and Regulation 965, for example, as well as other facility-specific legislation. In addition, the obligation on health professionals to protect the confidentiality of personal health information. So we'll talk a little bit about some of the key concepts. Privacy really has evolved through in Canada with when the federal privacy legislation came into play. It was really to catch up to our international partners to ensure that we were protecting personal information and not only the access and disclosure of information, but also what information we collect, how we collect it, what is the right of the individual to control who has access to their personal information and under what circumstances. So privacy is a broader concept. It really relates to informational self-determination. Confidentiality, in contrast, is the obligation on a person or an organization to protect information that's been entrusted to their care for a specific purpose. So if you are receiving health information relating to the provision of health care, it's the obligation of the health professional or the organization to protect that information and to ensure that only authorized persons have access to it on a need-to-know basis. Um, the duty of confidentiality has been found to be a fiduciary duty, so a duty of trust, which is one of the highest types of duties that can be on a health professional or other person. And then finally, the third concept that I want to talk about is security. And security relates to the preservation of confidentiality, integrity, and availability of personal information. It's the means of safeguarding privacy and confidentiality, whether it's administrative, technical, and physical safeguards, or in the planning, design, implementation, and monitoring of your systems and technology. You can't really have one of these without the others. So when we're looking at these concepts, they all have their own important rules that are important for the board and directors and senior leadership to keep in mind. When we're looking at the board's responsibility for privacy, there are the typical corporate responsibilities for ensuring that there are reasonable policies and procedures in place, that there are systems in place to ensure that there is appropriate oversight. So while the administrative team will be responsible for the day-to-day implementation and creation of systems, the board needs to ensure that it's asking the tough questions and ensuring that there is appropriate systems in place to address privacy. The board is also responsible for legislative compliance and for the organization. I'm going to talk a little bit now about the Personal Health Information Protection Act and specifically the board's responsibilities for PHIPA. The purpose of PHIPA is really important to keep in mind because the legislation establishes rules for the collection, use, and disclosure of personal health information to protect the confidentiality of that information and their privacy, while at the same time facilitating the effective provision of healthcare. And I highlight that facilitating the effective provision of healthcare because while privacy is very important, we still need to ensure that individuals have access to the information that they need in order to be able to deliver services and without creating barriers and issues. The Act relates to personal health information in the custody or control of a health information custodian. There are health information custodian is a defined term, and it includes a person who operates a public hospital, a psychiatric facility, a long-term care home, but ultimately, when we're talking about a person who operates, person can include a corporation, and so the corporation is the board. So the ultimate responsibility for privacy rests with the board of the hospital. The legislation also has the concept of an agent. And an agent is someone who acts on or on behalf of the custodian in respect of personal health information. So they're the ones who are actually carrying out all of the duties and functions of the custodian. All of your employees, your contracted independent contractors, third parties, are doing so on behalf of the health information custodian. The important thing to remember is that the health information custodian is ultimately responsible for the actions of its agents. And because of this, it's really important that as an organization, you have policies and procedures that identify how your agents are to be collecting, using, and disclosing personal health information. What are the rules that they need to comply with? Recently, there were some amendments to PHIPAA relating to notifications and also dealing with the obligations of health information custodians as it relates to their agents. The legislative changes prescribe that agents, the health information custodian needs to ensure that the agents are aware of the rules around their collection, use, and disclosure of personal health information. And at the same time, agents need to understand that they can only use that information as authorized by the health information custodian. In addition, there are new requirements that the custodian must notify an individual's regulated, where they're a regulated health professional, they need to notify the college if an agent's been terminated, suspended, or disciplined as a result of unauthorized collection, use, or disclosure, retention, or disposal of personal health information. The high-level obligations of a health information custodian are to comply with the Act, to adopt information practices, which are essentially your policies and procedures that address the how, the when, and the purpose for which personal health information is collected, used, and disclosed, as well as the safeguards that you need to have in place to protect that information. The obligation is on the organization to take reasonable steps to protect against theft, loss, and unauthorized use or disclosure, unauthorized copying, modification, or disposal of personal health information. So it's really throughout the entire life cycle of the information, from the time of creation to the time that it is disposed of, ensuring that that's done in a secure way. There's an obligation to ensure accuracy of personal health information, which obviously, if you are providing patient care, you need to ensure that the information that you're collecting is reasonably accurate for that purpose. There's a mandatory obligation to notify the patient or the patient's substitute decision maker at the first reasonable opportunity if personal health information is stolen or lost, or if it is used or disclosed without authority. One of the new requirements is the explicit statement in a notice to the individual that they're entitled to make a complaint to the Information and Privacy Commissioner upon being notified. And as of October 1st, 2017, there's also a mandatory requirement to notify the IPC of the theft or loss or unauthorized use or disclosure of personal health information in certain prescribed circumstances. And the circumstances are set out in the regulation. It's very comprehensive, so In most instances, um, there is now a mandatory obligation to notify the Information Privacy Commissioner, whereas previously it was done on a voluntary basis. Other requirements of the custodian, there must be a contact person who's responsible for privacy, who will facilitate compliance. They will train and inform agents of their obligations and address inquiries, access and correction requests, and receive complaints. And there must be a written statement describing the organization's information practices, which is available and accessible to the public. I set all of this out because, again, it's the as a director with oversight responsibilities, it's important to understand what your obligations are under the legislation, so that you can ensure that you are addressing the issues from a systems perspective. The next legislation I'm going to talk about is FIPA, or for some organizations, they're subject to the Municipal Freedom of Information and Protection of Privacy Act. FIPA, of course, being applicable to public hospitals and government agencies and LINs and a number of different types of organizations. But from a board perspective, I think what is important to understand is the legislation provides a right of access to the public to information which is held by institutions. The underlying concept is that information should be available to the public, subject to very limited exceptions. And that there must be an independent body to review decisions on disclosure relating to government information. So even though the legislation now applies to a number of health service providers, the legislation is drafted in terms of government information, institutions, and where you see the word institution, you can read public hospital or LIN or whatever other organization it's applied to. It applies to. The second part of PHIPA relates to the protection of privacy of individuals whose personal information is held by an institution. And provide a right of access. These provisions limit the institution's the collection of personal information, as well as the use and disclosure to ensure that it's in accordance with the Act. And there are, again, there's a right of access to any document or record in the custody or control of the institution, and you need to provide it subject to limited exceptions and exclusions. FIPA is extremely process-driven. There are specified timelines for response. There are requirements in terms of how you respond and how you deal with third-party information or personal information of others. There is a lot of case law that's developed around the application of exemptions or exclusions. For example, there are certain exclusions relating to labor and employment information with certain exceptions for example, executive contracts, which are subject to a right of access. There's a statutory right of appeal process, and then rules relating to the protection of privacy. One of the biggest implications for organizations that are subject to FIPA relates to your document management processes, particularly because there are these statutory timeframes that you are required to comply with, and individuals are entitled to have a directory of records so that they understand what your record holdings are so that they can request access. Um, so when you're looking at specific exemptions that may apply to confidential information, whether it's information that's protected by solicitor and client privilege or information that deals with the economic interests of the organization that is not something that should be part of public access, you really need to be thinking about how you document that information, what you document, how you store and retrieve information, as well as the retention and destruction of information. The definition of head, so the head is really the decision maker under FIPPA for the institution. The head is responsible for decisions by the institution as well as overseeing the administration of the act. And in this case, the head for a for a public hospital is actually defined as the chair of the board. So once again, it's that authority and those obligations rest at that board level. Well, how do you actually carry out that function? It's through delegation, and the Act allows for the delegation of certain powers and duties. And typically, there will be certain individuals within the organization that are granted authorization for different tasks. So there's usually a senior leadership lead, and then a freedom of information or access to information coordinator who will have authority to deal with access requests. The delegation must be in writing, and there ultimately the head or the chair remains accountable for actions taken and any decisions that are made under the Act. So the final concept I wanted to touch on is information governance, because privacy and security really fit within a broader framework of information governance. I have a definition here from the American Health Information Management Association. They describe information governance as the organization-wide framework for managing information throughout its life cycle, and for supporting the organization's strategy, operations, regulatory, legal, risk, and environmental requirements. And when you think about it, organizations have a huge amount of information in addition to personal information of employees, of others within the organization. There's also patient information, but on top of that, there's your confidential business information and your informational assets, all of which are really important to ensure that you have a strategy to ensure that you can preserve information that you need from an ongoing business continuity perspective, to reduce your operating costs and improve efficiency. It can be very expensive to store information. And if it's not accessible, or if there's no need to preserve that information, having systems in place to ensure that you have proper retention and destruction policies. Privacy and cyber risks are a very prevalent area of risk today. It's now become clear that it's not a matter of if, it's a matter of when organizations are subject to cyber attacks. My looking at statistics from my own firm in the first uh, 8 months of the year, we received 39 million emails that were processed through our IT department. Of those, only 6 million of those made it through our firewalls and our screening techniques. And even within that 6 million, we still received fraudulent emails. We received emails that containing malware, many different types of risks that are potentially subject to exposure by individuals. They're particularly in the health sector. With the ongoing growth and reliance on the use of technology, electronic medical records, electronic communications, medical devices, and monitoring technologies, all of these are really great from a care perspective, but there are security risks that are and privacy risks that are introduced whenever you are adding in new technologies where they're interconnected. On top of everything, we have a very complex regulatory environment. The standards are continually evolving, and as publicly funded organizations, there are resource constraints. And organizations need to live within their budgets. So when we're talking about privacy and cyber risk, we're talking about a number of different risks. So there's risk of financial loss, of disruption, of stakeholder dissatisfaction, of legal consequences or damage to the reputation of an organization relating to either the collection, use, and retention or disclosure of personal health information, which is the privacy risk, or some sort of failure of your information technology systems, which we refer to as cyber risk. And of course, a cyber threat may involve personal health information and trigger privacy obligations. When I talk about some of these types of risks, for example, stakeholder dissatisfaction, again, this is one of the, from a business perspective, you can be so privacy and security conscious that it's actually a barrier to be able to access information to the point where it creates dissatisfaction on the part of patients or on the part of your internal stakeholders. So getting the right balance is important. Damage to the reputation of the organization is a huge issue, particularly because we do have the obligation to notify when there's been a breach. And so it's a information that is potentially public in every situation. Some of the cyber attacks have really focused in on the health sector for a number of reasons. One, personal health information is very valuable. It is, when you have something like a credit card, it has a very short shelf life. So someone steals your financial information, your credit card information, you cancel that credit card, and then there's no benefit to it. Personal health information is enduring. It is information that can have uses for a long period of time. In addition, health organizations tend to be slow to adapt. They are very vulnerable to human error. They use a wide range of communications technologies, and things are interconnected. And investments in IT security and privacy training really cannot keep pace. One of the examples of cyber attacks that has gained a lot of attention are ransomware attacks, to the point that the Canadian Medical Protective Association issued a warning and an update to its members to highlight the need to ensure that you both have security safeguards in place, but also backup plans, so that if there is an issue around information being compromised, that you have a contingency plan in place. A recent ransomware example comes from the Erie County Medical Center. And in this case, there was essentially the way the ransomware worked is the data on the system was encrypted. In order to be given the encryption key so that they could use the data, they were demanding $30,000 in Bitcoin as ransom. In that case, they did not pay the ransom, and they were able to restore much of the information from their backup systems. Luckily, personal health information wasn't directly involved in this situation. But this $30,000 ransomware resulted in $10 million of the organization to rectify the situation from both an IT perspective as well as training, redoing systems, and bringing in the experts that were necessary to address the situation. So they can be have very significant consequences. So in addition to the increase in cyber attacks, there are concerns about identity theft. I mentioned that there are new emerging privacy torts for breach of privacy. The two that are most well known are intrusion upon seclusion, which is one that has been used in a number of class actions involving unauthorized access to records of personal health information in hospitals, as well as a number of different industries and sectors. So the idea here is that there are some intrusions or some breaches that are so egregious that the courts have found that there ought to be a remedy for individuals where there's been willful or intentional breach of confidentiality, where objectively an individual this would be seen as a breach of their confidentiality, and in these situations, there's no need to actually demonstrate any harm or damage to the individual. So there is a cap on the amount that courts will award for mental distress, but it's all you need to demonstrate is that you meet the requirements of the privacy tort in order to be successful. the another privacy or tort that is also emerging is relates to public disclosure of private facts. And one of the first cases involved the access to um, medical marijuana program where the federal government sent out notices and identified the program on the envelope to the particular patient. So essentially identified that that individual was part of this program and was receiving medical marijuana. So again, that was it became a class action. We are these matters are working their way through the courts, and so although a number of them have been certified and are proceeding, we're still waiting to hear how they're going to be treated substantively. So strategies to reduce risk. So prevention obviously is the best strategy. Know where you stand, know what information the organization has, identify, assess, monitor, and report on your risks, and ensure that you've addressed your systems responsibilities, whether it's the information practices that you have, relating to privacy and security, as well as the protection of your informational assets through the entire information life cycle. Some of the learnings that we have had through decisions of the Information Privacy Commissioner and through our experience with privacy legislation has revealed some important lessons. It's not enough to have privacy and security policies in place. An organization needs to be monitoring and auditing their compliance. And that could be regular as well as random policy audits, ensuring that you have the ability to create an audit trail when you are using electronic data, engaging in security testing for your systems. You also need to evaluate the use, the standards as they evolve over time. So for many years, and there are still many organizations that still use fax as a delivery system. But as things have evolved, for example, encryption, it's much more reliable and accessible now, and much more secure than some of the methods that we've used in the past. So as those things change, organizations need to make sure that they are looking at these changing standards and evolve with them. That can really involve engaging with subject matter experts. You're not obviously, and you're not expected to know everything yourself, but you are expected to ask the questions and to ensure that you're engaging individuals who are knowledgeable about the subject and to use reputable vendors. One of the best strategies is to ensure that your vendors demonstrate their compliance with privacy and security standards, whether through contractual language or through demonstrating that they have done privacy impact assessments or security testing to satisfy you that they are able to adequately protect your information. Training and education, this is something that is an ongoing obligation. It seems to be never ending, but at the end of the day, privacy and cyber risks are as much about people as they are technology. And human error is, um, or human judgment is the root of so many privacy and cyber breaches that we see, that I really can't emphasize that enough. Um, Service provider management, whenever you're introducing a new vendor that has connectivity or that is going to be having access to personal information, making sure that you've properly vetted them, that you have contractual protections in place for the organization, and that you are satisfied that you've undertaken risk assessment tools for new systems, new technologies, and including privacy impact assessments. Internal reporting, that really relates to systems for identifying and preventing breaches. Um, if something happens and an individual raises a concern, is that being reported, and is that going to the right person within the organization so that they can deal with an issue early on? Some of the early privacy decisions by the IPC actually related to concerns where an individual was concerned about her husband being aware of her information. The organization treated it as a security issue, but it was also a privacy issue in that part of that protection was protecting that person's personal health information. So you need to be able to recognize when it is a privacy issue so that you can appropriately address it. A few final comments. Privacy and cyber risk management is really well suited to enterprise risk management frameworks. So if that's something that you have in place, or is that something that you're contemplating, it can be a really effective tool, because it allows you to align management's responsibility to manage the operational risk with the board's responsibility to ensure risk oversight. And it gives management an indication of how the board wants risk to be managed within that organization's risk tolerance. There are a number of strategies that you can look at for managing risk, whether it's avoiding the risk altogether. If you're not satisfied, for example, that a technology will meet your organizational standards, you can remove it by discontinuing obsolete or faulty software. You can change the likelihood or reduce the likelihood through training, policy development, privacy impact assessments, and other risk tools. You can change the consequences. You can share or transfer the risk, for example, through cyber insurance or outsourcing or contracting out certain functions. And then finally, retain risk, and this really is an informed decision that you need to make. And unfortunately, given the resource constraints, there are times when organizations need to live with their legacy systems and technologies, knowing that at this point in time, it's not possible to replace them. So when breaches happen, it's really important that you know who to contact and what to do. So some of the minimum requirements are to have a privacy breach protocol in place to address those first steps, to have a cyber incident plan so that you know organizationally what the steps are immediately that you can take without having to scramble to try to put a plan in place, as well as crisis and disaster management, and etc. Responding to privacy and cyber breaches can be extremely costly and time-consuming in terms of resources, as well as if you need to bring in external resources, forensic and security experts, for example. Early engagement of experienced legal counsel can be very critical, both in terms of helping to guide you through the process, as well as establishing solicitor and client privilege for your investigations. There is significant public relations and legal risk that can be associated with these issues. So how individuals are notified becomes extremely important, including a strong communication strategy. You can consider risk transfer and specialized insurance. There are a number of different coverages that are available for organizations, and finding someone who's knowledgeable about what those products are and how they apply to an organization is a time well spent. In conclusion, awareness and engagement by the board and senior leadership around these issues is really critical to ensure that you can foster effective decision making. There's a lot of prioritization and competing issues that you need to deal with. So having a robust process for identifying and prioritizing privacy and cyber risks and organizational priorities is a key exercise for any board. And then finally, ensuring that privacy is supported from the most senior levels through the allocation of resources to allow those who are on the operational level to manage those risks. So with that, I will open the floor to questions. We don't have a lot of time, but I will certainly do my best within the time that we have remaining. All right, I have a question. How do we reconcile our need to mitigate risk with respect to privacy with our need to mitigate risk with respect to appropriate care when the former may adversely affect the latter? We have discovered that our attempts to enable better sharing of patient information when a patient is transferred from one unit in the hospital to another may violate the privacy provisions. So there really are, this is the balance that we're always trying to meet when we are dealing with privacy issues. And I think if we take it to first principles and look at, the need to know and ensuring that individuals actually are really only accessing information that they need in order to be able to provide patient care, particularly when they're being transferred between units or they're being transferred to another organization, it requires every individual to give it some thought. When you are, different organizations have different ability to control access to individual users. And so ensuring that the access rights are appropriate to the individual's function when you are able to do that is very important. If you aren't able to do that, ensuring that you are auditing the the use of personal health information becomes even more important because you really are relying on an honor system, and um, one of the and you need to make sure that you are um, scrutinizing or monitoring for compliance, whether it's spot audits or if there's a particular um, issue like a VIP or other well-known individual undertaking specific audits relating to that individual and access. I don't see any more questions at this time, but as I said, please feel free to reach out if you do have any further questions. Thank you very much for attending our session today. We would appreciate if you could take a few minutes to fill out our survey. And I would also like to remind you of our next and last regular coffee talk session for the year, which is entitled The Anatomy of a Contract, a Risk Management Perspective. And that will take place on December the 5th. The invitations have already gone out, so hopefully you've received it. And if you haven't, please also feel free to contact us, and we'll make sure that, that you're added to that list. Thank you very much, and bye for now.